All right, so my task was to talk about leave for the first 16 minutes. And I found that a little bit challenging because I didn't want to talk about COVID-related leave, because we're going to do that later. And I didn't want to talk about the earned paid leave law, first of all, because I'm tired of talking about it, but also because we're going to do that later. So that left me with what other leave issues might there be at this point. And I did come up with some things that I want to share with you about the FMLA, both state and federal, because they actually turn out to be quite important. Some of them are a result of the COVID situation, but not directly related to it. And some of them are just reminders for you. So the first thing is that there are new forms, federal forms, and you can find those, of course, on the DOL website. I think they redid all of them, but the ones I'm going to talk about are the Notice of Eligibility of Rights and Responsibilities, as well as the certification both of the employee's own serious health condition and that of a family member. These were issued in July. They say that they expire June of 2023. They are not mandatory. I don't know if people realize that you are not required to use these forms. Quite frankly, I think you would be remiss in not using them because the whole point is that it limits the information that you're entitled to have. And as we all know, you do not want to have more medical information than you are permitted to have. So I would strongly recommend that if you don't know these are out or haven't gotten them ready to use, that you do that. I wanted to just go through briefly a couple of the changes in these, and just be mindful, these are the federal forms, but you may still use them for state requests. So if you have somebody who's covered by state FMLA but not federal, you know, Maine doesn't have their own forms, so you can use these. So on the Notice of Eligibility of Rights and Responsibilities, you know, I have to, from a personal standpoint, it looks to me like these forms are a whole lot longer than they used to be. So why they're calling them less complicated, I'm not entirely sure. But what they have done is added some sections, and I think the idea was they are intended to have less narrative, especially from the certifying physicians, so that you end up with less medical information. And also, I think hopefully to make an employee's rights and obligations more clear to them. What I think it's going to do is probably require some additional work on your part. Because, for instance, on the Notice of Eligibility of Rights and Responsibilities, you now have to inform somebody, if they do not meet the eligibility requirements, how short they are in terms of time to meet it, and also both in terms of the 12-month length of service and the 1,250-hour requirement, which I don't necessarily think is a bad thing, because you ought to know that anyway, and so there's no reason not to communicate it to the employee. Plus, if there's an issue about it, then it can be dealt with right away, as opposed to denying the leave and then having them come back later and fuss about it. I've seen some commentary about one of the sections in here where it's talking about what the 12-month period is, and because it lists out the 4 ways to calculate that period. So, you know, in other words, calendar year or fixed year, or the 12-month measuring back, or the rolling. But what it doesn't do is make it clear that those are not the same thing as intermittent leave in terms of calculation. And so I guess there's some concern that employees may not understand how intermittent leave is calculated, so you may just want to be aware of that. And then the final thing I wanted to point out about the Notice of Rights and Responsibilities is that on page 3, there's a substitution of paid leave section now, and it requires you to check off several different boxes about whether or not leave is paid and whether they have to use their own accrued leave. And then there's an other box that talks about whether or not you're going to offset this based on STD or workers' comp. I think that this is interesting because this is going to be impacted by COVID potentially, especially if we have a new FFCRA that starts up in the new year, which we may very well. So that's the Notice of Rights and Responsibilities. And then on the designation forms, both for the serious health condition of the employee and the designation form, it goes through the steps now that an employee needs to take to amend an incomplete or insufficient certification. And it requires you to explain to the employee what's missing or insufficient, and hopefully that will work out well as also because it will be hopefully easier to clarify with the employee what they're missing. In terms of the qualification or the certification of the employee's own serious health condition, one of the things the form now asks for is for the healthcare provider to describe at least one essential function that the employee is not able to do that would qualify them for FMLA, which is a new thing. And interestingly, on the certification for the family member, it now asks what the particular service is the employee is needed to provide, because you'll remember this comes up many times every year, and because technically it's supposed to be of medical necessity, but that term has been interpreted extremely broadly to include anything from medication management to taking somebody to appointments to bringing them home from a nursing home, but even to providing things like psychological care and moral support. And in fact, even going to a nursing home, for instance, to get somebody situated or deal with issues there. So that's been very broad, and that they'll be asking now for specification as to what kind of care is needed. So I think that will be helpful as well. Okay. Since there were new forms, that prompted me to think about one of the categories of FMLA, and I'm not sure I've ever talked about this in a seminar, and it seemed like we should as a reminder, and that is that of course, one of the reasons for an FMLA leave is for the birth or adoption of a child or to bond with a newborn. And so what I was thinking is, what kind of form does one use for those situations? And it turns out there is no form. And so I want to make sure that you're not trying to apply one of those forms, because if the baby and the mother are healthy and it's a bonding issue, then there's no medical certification to be had. So you would not be using the medical certification for the employee's serious health condition. And so you can make your own form. You can sort of document this however you choose to document it. I did look up, though, what you're entitled to know. And it turns out that you're entitled to request documentation to confirm the family relationship when somebody asks for bonding leave. So, I mean, good luck with that. I don't know that there would be a situation where you really would want to question that sort of thing. But if you do, you are permitted to ask for that documentation. Although the DOL does point out that if it's the employee is the female who's been pregnant and has been working for you, it wouldn't make a whole lot of sense or be very reasonable to ask her for documentation of the need for bonding or the delivery. So don't do that. It also says that you can ask for documentation of the qualifying family relationship in the event, I suppose, if you have a male who's asking to take FMLA leave for the bonding, then you can ask for that kind of documentation if you feel like you need it. Again, though, be sure you are treating everybody consistently. So if you're going to ask for that documentation from one person, you're asking for it from everybody. And the DOL goes on to say that if you do decide to ask for that information, it can be satisfied by the employee providing either a simple statement asserting their family relationship or documentation like the birth certificate or a court document. Of the employee's choice, mind you, you're not permitted to ask for one or the other. In terms of the, now keep in mind that these forms of leave have to be taken within 1 year of the birth or placement for adoption. So that's the bonding leave, not the medical leave associated with a pregnancy if there is any, but the bonding leave and also the placement for adoption. The other thing is, keep in mind that an employee can ask for covered FMLA leave for, well, not so much the bonding, but for the adoption or foster care prior to the actual placement. So I know, I mean, John and I went through this, and we had to go to so many meetings I can't even begin to imagine about a variety of things. And that time can be covered under FMLA for the adoption or foster leave as well. And I don't think most people realize that. So there's that. Karen, how am I doing on time?
You have 7 minutes.
I have 7 minutes. Okay. So the next thing I want to talk about, still under the FMLA, is telemedicine. because if you don't already have employees who are treating by telemedicine, you certainly probably will. And I know at least in the workers' comp world, a lot of treatments are being handled that way now because of COVID, of course. And so the question came up about whether or not telemedicine is covered as a form of treatment under the FMLA. And it would be a fairly creative argument to try to say that it's not, which is not to say that that hasn't or won't happen, but the DOL has weighed in on this just in case it comes up. And they have said that, well, just to back up a second, so the requirement is if there's not inpatient treatment, as you probably know for this certifying under the FMLA, there has to be an in-person treatment visit within 7 days of the first date of incapacity, and then continuing treatment after that. And that's one of the ways the employee qualifies for their own personal medical leave. So the question, of course, is, well, if they're being treated by telemedicine, does that still count as an in-person treatment visit? So the DOL actually specifically did address this in that, and we're going to make reference today to a bunch of different DOL documents, I'm sure, and all of those can be found on their website if they're not already in the materials that we have attached to this. A lot of them we did not, print out and attach just because they're extremely lengthy, but they have a document called COVID-19 and the Family Medical Leave Act question and answer. So that seems relevant and important. And it turns out that they did address this, and they clarified that a telemedicine visit will be considered an in-person treatment visit if the visit includes an examination, evaluation, or treatment by a healthcare provider, is performed by video conference, and is permitted and accepted by state licensing authorities. So, note the requirement that I read that says video. So a telephone meeting is probably not, or at least under this definition, does not appear to be enough. And I find that interesting because I have, in the comp world, I have people treating with psychological providers, not for a physical problem, and they are doing those meetings by telephone now. And so arguably those do not fit within this definition and may not be considered in-person treatments. In addition, so, that's something to be aware of. In addition to that issue, the DOL also, well, first of all, it emphasized that this is only true through December 31st, 2020. Isn't that what year we're in? Yeah. 2020. Because all of the FFCRA and all of the COVID rules the DOL has issued pretty much expire as of December 31st, 2020. And so presumably we're going to get updates at some point between now and then about what's continuing and what's not. And so we don't know, but at least as of right now through the end of the year. It also says that during the same time frame, so only up until the end of the year, electronic signatures are acceptable on documents used to establish a serious health condition. So if the employee presents his or her certification of a serious health condition to you with an electronic signature and presumably filled out electronically as well, you have to accept that. It doesn't mean that you have to accept something that's less than completely filled out. You're still entitled to all the information that you're entitled to have. But it can be signed electronically. Okay, so that was the telemedicine rule. Now, the other thing I want to talk about under the FMLA is what's happening with people working remotely, because, of course, as you know, many of the employment laws that we deal with have minimums in a place of employment. So the ADA, for instance, only applies when you have 15 or more employees. But there are guidances about, especially under the FMLA, about where they have to be working. So, for instance, the federal FMLA said that an employer is only covered, right, if they have 50 or more employees within a 75-mile radius of the employee's work site. So now one of the issues that's come up is if I've got some percentage of my workforce who is working remotely and is no longer in the office, do those people still count? And does that mean, of course, I had somebody go ahead and ask, so does that mean that if I have them all working remotely, I don't have to provide FMLA coverage anymore? And it turns out the answer is no, not surprisingly, because the DOL has also specifically addressed this. In fact, it was addressed long before COVID. There's been a regulation on the books for a long time about an employee's personal residence. And what it says is an employee's personal residence is not a work site in the case of employees who travel or generally leave work and return from work to their personal residence, or employees who work at home under the concept of flex-a-place or telecommuting. So they anticipated this argument, maybe not for COVID, but at least for other things, and said, in other words, home offices are not considered the work location for FMLA purposes. So you have to count that person in the office from which assignments are made. So if we have an office in Bangor, we've got people working remotely, those people count in terms of whether or not this physical office is covered by the FMLA requirements. I'm at the end of my time. I just want to point out, state does not address this at all. The definition says that you employ 15 or more employees at one location in the state. And because it uses the word employee, I think I would apply exactly the same analysis and count those people regardless of whether they're remote or not. So that's the conclusion of my portion.